But I just watched a video. It is midnight. I just finished a workout and something clicked. I watched a video that made something else click that I watched earlier today, and that's this. The kid calls for a tow. The woman, Vicky, calls the captain to do the tow. And she says, this kid's grandfather, this Jerry Ackerman, is a member. Before she says the guy's name, the captain says, Jerry? I just got off the phone with him. I literally just got off the phone with him. And he said that they don't need a tow, that they're fine. So, hold on. The grandson is calling for the tow simultaneous to the grandfather calling the captain of the towboat saying they don't need a tow before the captain gets a call from Vicky. When did the kid call the grandfather? While the boat is sinking? He called grandfather for what could grandfather possibly do for you? He called the grandfather for what the fuck do we do? This kid's grandfather said, you got to make a fucking trail that you tried to get help. There was an accident. Something happened. The boat's going under. Okay, it's a boat. Call. So there is a recording of you trying to get help for something, and we'll figure it out later. I think that their story has evolved. But that was what the grandfather thought of then, to create a timestamp in history of what was happening, what they were doing, where they were, and that there was a completely different emergency happening, nothing to do with Nolan, okay? And the grandfather did not want to get billed for this tow, and obviously didn't want the captain to go and happen upon whatever the fuck's going on. So he preempts the emergency call to the captain and says, hey, you might get a call, but they don't need it. I walked them through it. It's fine. It was an alibi advised by the grandfather. You remember the Murdoch documentary series? You remember that, right? You remember when his son killed a girl in a boating accident, right? And how they completely jumped into action immediately without skipping a fucking beat to do a cover up. They all get back. They all wipe in unison, all wipe their social media. Why would you have to do that? Well, why the fuck would you have to do that? If you left him on the island, why are you deleting all of your social media? Another thing.
I couldn't imagine that they want to get underage drinking on camera. So what they had articulated to me that it wasn't abnormal for people not to snap and not to do a lot of pictures and things like that because they were focused on.
But you told me they showed you pictures and videos.
Yeah,
so
but
they
it's
did
not
take
uploaded.
pictures and videos.
No. It's not. It's not a lot of pictures, and they weren't uploaded.
Shut the f- up, Brandon, because he is spinning his wheels here, trying to convince Nancy that the boys were telling the truth. They let me see their videos on their phones. And that, of course, they wouldn't want to film themselves drinking. They all film themselves drinking. No, but they wouldn't upload it onto Snap. Here's why he just f***ed up. The mother, one of the first days after this all happened, the mother said, we wanted his phone because he had snapped, and we wanted to see the snaps that he had snapped, and the snaps were deleted. So she had seen his snaps. The whole point of Snapchat is that you are able to post things that maybe you don't want a record of, but at least everyone knew you were having fun.
He was the peacemaker of our friend group. I mean, anytime anybody had beef over somebody, over a girl or whatever, he would go over there and start talking to him. He's like, man, I think this guy's actually pretty cool.
Yeah, this guy's
I don't think
cool.
I think we should become friends with this guy. Yeah. And lo and behold, we would somehow become friends with the dude, even though he's getting with one of our other buddies' exes or whatever. But he was.
If your son goes out on a boat, especially with a group of black kids, and doesn't come back, but they all come back safely, and then those people lawyer up, they deactivate their social media accounts, and they say that your son did not bring his cell phone with him. You know, like would that make sense to you? It doesn't. Logically, it doesn't make sense, right?
But I believe one took a polygraph, and from what was told to me, that they all passed.
Nancy, my clients have not taken a polygraph test.
Excuse me. Everybody is now pointing out that Charles and TMZ are now backpedaling on everything they said, because Charles was recently being interviewed, and I think it was by Don Lemon, and he's like, yeah, it's odd that they're going off on Officer Race Batum Tatum's podcast. It's odd that they did this. It's odd that they did that. But TMZ, you have been the ones supporting these young men's PR crusade this entire time. So why now are you finally flip-flopping? Is it because all of the backlash you've been getting for reporting on this so incorrectly and favoring one side over the other? Because every time Harvey was on there, he said, oh yeah, we've corroborated the footage with them on the CTO call. And then when Trent Out Loud, shout out, burr, 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 to my man's is Trent Out Loud said, where is the metadata? Where is the META? Where is the META, son? We need to see it all day, son. Where is it? Where's the metadata? And Harvey's like, oh yeah, we just believe them. So I'm glad TMZ is backpedaling, but you guys should have been on this from day one. Because one thing about TMZ, we all respected you on that celebrity tip.
There's video showing the boat leaving Horn Island that day. Nobody disputes that. What we don't have, and what nobody has produced in 6 weeks, is even 1 second of footage showing that same boat, or anyone aboard it, actually coming back. Tonight, we're going to examine that gap because it's real, it's confirmed, and so far, it has never been explained. We're also going to take a closer look at the 6 o'clock witness claim, something very few people covering this case have seriously examined. We'll bring in an actual trial attorney and test that claim against the real legal standards used for eyewitness identification: distance, lighting, whether anyone had been drinking, and whether anything obstructed the view. Once those questions are applied to the footage being used to support the claim, it doesn't appear nearly as solid as it has been presented. And tonight, we're going to clear up something else that has been seriously misrepresented: Nolan's own phone and whether his family has actually been cooperating with efforts to turn it over. What we found is not what you've been told. There is a documented timeline with specific dates, and it paints a very different picture from the claim that the family simply won't hand it over. We're also going to ask a direct question that a Florida attorney raised this week, one that still hasn't received a convincing answer. If there is no criminal investigation underway, then why is there a grand jury? There's another thread we want you thinking about throughout this entire discussion, because when you lay everything out step by step, it becomes difficult to understand. Warren calls Javin instead of calling Christine directly. He contacts Javin specifically to get Christine's phone number. So ask yourself this: if Warren needed Nolan's own mother's number, wouldn't Javin naturally wonder why? Wouldn't that suggest Javin already knew something was wrong before Christine ever contacted him herself? But the timeline says Christine later had to call Javin and Tashima to tell them that Nolan was missing, which would only make sense if Javin didn't already know. Those two things cannot both be true at the same time. Somewhere in that timeline, there's a gap. And while we're talking about Javon, he's the one who said it was unusual for Nolan to leave his phone behind that day. That's a fair observation. But there's something else worth considering. Javon also left his own phone on that same boat on that same day. We want your honest take on that. Every one of these issues is real. Every one is disputed, and each one deserves to be examined honestly instead of being shouted down or brushed aside.
These witnesses know Nolan. They've known him for a long time. They were able to make a positive ID. And they told that to investigators. They told them that from the very start.
What witnesses? Where? Who, what, where, why, and when? That is a renowned trial lawyer named Tyler Cox, and he is representing the acquaintances of Nolan's that took him to Horn Island on their boat, the Triton. Curious, we've seen, hey, let's pull up that video, control room, of everyone getting on the boat before they went to Horn Island. It's very interesting, evidentiarily. Okay, here we go. This was from the Officer Tatum show, and you're about to see people. There they are down at the right. And there's actual video of people see the boat at about 1 o'clock. Oh, there we go. Excellent shot, guys. People are getting on, people getting off. And it keeps going to where you see everybody that got on the boat. But here's my big question tonight, before I can even get to the alleged witnesses that Tyler Cox is telling us about. Dave Mack, joining me, Crime Stories investigative reporter. Can I see the video again, please? Dave Mack, I'm seeing everybody preparing the Triton to go out, preparing to go out. In this shot, they're down at about 3 o'clock. Okay, keep looking. 3 o'clock, 3 o'clock, 3 o'clock. And then suddenly you switch to a different camera. There you go. That's the boat. So, Dave Mack, where is the evidence? Where is the video of the boat? Is that Nolan right there? Walking along the light blue shorts, and he at that time had on a white shirt. I think that's Nolan right there. Dave Mack, where is the evidence, the video evidence of them coming back?
Nancy, we have not seen evidence of them coming back.
Let's begin with something that isn't a theory, isn't an enhancement, and isn't someone's interpretation of a blurry image. It's a straightforward, confirmed fact about what does and doesn't exist. That's Nancy Grace asking her own investigative reporter directly on air and receiving a clear answer. Actual footage exists of the Triton getting ready to leave the dock that morning. People loading up, boats preparing to head out, and a complete visual record of the departure. Somewhere in that same footage, there's a person wearing light blue shorts and a white shirt bent over near the boat around 3 o'clock. Nancy herself identifies that person on air as likely being Nolan. What doesn't exist, according to a crime reporter who has been following this case closely, is even 1 second of footage showing any of those boats coming back. Not the Triton, and not either of the other 2 boats that traveled out toward Horn Island that same morning. 3 boats went out. As Dave Mack himself said, there are different accounts about when each one actually returned, but there isn't a single video frame confirming any of them. Now, think about the actual timeline because this part matters. This isn't a gap from just a few days ago. More than 30 days have now passed since Nolan died. During all that time, through every panel, every interview, and every piece of video that has circulated in this case, the departure clip remains the only visual evidence anyone has publicly produced. More than 30 days, and nothing showing the return has appeared. Not from investigators, not from the family's team, not from the friend group, and not from anyone else. Here's the question worth asking plainly, and it's simple. Why would a camera record the boats leaving but somehow not record them coming back? This isn't random footage from a bystander who happened to be filming at exactly the right moment. This is dock and marina security coverage. The kind of system designed to operate continuously on a loop, regardless of what's happening in front of it. It doesn't switch on for departures and then shut itself off for returns. It doesn't know which direction is more important. If that camera was operating and recorded 8 people getting onto a boat that morning, that same camera, running on the same loop, should have recorded whatever returned to that same area later that day, unless something specific prevented it from recording or affected the footage afterward. That's exactly why saying maybe nothing else was captured isn't really enough as an easy explanation here, the way it might be with a random phone video. A continuously running security system doesn't simply record boats leaving and then selectively miss them returning. Something has to explain that difference. Either the return happened outside that camera's particular field of view, or the footage exists and hasn't been released, or the footage existed and has since been lost. Those are several genuine possibilities, and none of them automatically require a conspiracy. Most commercial security systems overwrite older recordings automatically, often somewhere between 2 and 4 weeks, making room for newer footage. We're already beyond that time frame. If an official preservation request was made during those first few days, before the system automatically cycled through the recordings, the footage could still be stored somewhere and potentially recovered today. But if nobody requested it in time, it could already be gone permanently. Not because somebody intentionally deleted it, but simply because the system followed its normal schedule. These systems don't pause their recording cycle because a case is unfolding. Look at the actual numbers against the timeline, because this matters more than it may seem at first. More than 30 days have already passed, which is beyond many standard retention periods for ordinary commercial security systems. So if nobody formally requested and preserved this footage during roughly the first 2 to 4 weeks after Nolan's death, there's a genuine possibility that it has already been overwritten. Again, not because someone decided to destroy evidence, but because that's how these systems are designed to operate, continuously looping until someone intervenes. That means the opportunity to get a clean answer to this specific question may already be shrinking, assuming it hasn't disappeared completely. It's also important to acknowledge the more ordinary possibility, because a serious investigation shouldn't automatically assume the worst. The camera recording the departure may simply not have a field of view reaching the location where the 3 boats eventually returned. Marinas can have several different docking areas, and a camera positioned to cover one section of water may not see another part of the same facility. If the boats return to another slip, a different ramp, or even another marina altogether, that could completely explain why departure footage exists while return footage doesn't, without requiring any footage to have disappeared. There's another layer here that's worth considering because it makes the situation even more unusual. This isn't simply missing footage involving one boat. It's a gap involving 3 boats, each with its own separate account of when it actually returned. If even one of those 3 boats had confirmed return footage, that alone could significantly narrow the timeline this case has been debating for more than a month. But there isn't confirmed return footage for any of the 3. That means every current account of the return journey ultimately depends on someone's statement, with no independent visual evidence anchoring those claims. Here's the fair counterargument, using the same standard we've applied throughout this case. It's possible that a request was made early, the footage was retrieved and reviewed privately, and investigators simply haven't released it because it didn't add anything beyond what they already knew. Law enforcement doesn't publicly explain every piece of evidence it considers or rules out. That's a reasonable possibility. But from the public's perspective, that explanation looks exactly the same as the possibility that nobody ever requested the footage. In both situations, all people see is complete silence more than 30 days later. The only thing that separates those 2 possibilities is someone with actual authority confirming which one is true. And as of tonight, nobody has done that. What would actually resolve this isn't complicated. Marina operators and dock owners either still have footage covering that stretch of water on July 4th, or they can confirm that the recordings have already been overwritten. That's a straightforward question with a straightforward answer, not a theory. A simple yes or no. A formal records request could settle it directly, assuming any footage is still within the remaining retention window. It's also worth pointing out that the departure footage we actually have didn't come from an official release. It surfaced through the Officer Tatum show, an independent platform rather than a law enforcement press conference. If the only footage the public has seen from that entire day more than a month later came from outside the investigation itself, that raises another quiet question about what official channels have actually released on their own during this entire period. None of this proves that anyone is hiding anything. Maybe the camera was pointed in the wrong direction. Maybe the retention period quietly expired before anyone requested the recording. Maybe investigators already obtained the footage privately and simply haven't announced it. All of those explanations are possible, and we shouldn't ignore them just to make this part sound more dramatic. But more than 30 days is still a long time for what could be the most objective category of evidence in this entire case to remain this one-sided, showing people leaving but never showing anyone coming back. And if you were anywhere near that marina that evening and happened to capture footage of your own, that's exactly the kind of information that could potentially help move this investigation forward. It's worth submitting.
Wait a minute. Time out. Those boys just said that who left their phone on their boat in the case of 18-year-old Nolan Wells and had to meet them back at the dock and wait for them in order for them to get their phone? Let's listen to it together and I'll be right back.
5 other people that also left their phones on the boat, and we had to wait at the boat launch for them to come and pick them up, including Javon. I mean, Javon left his phone on our boat.
For one, I found it very strange that they looked at each other at that precise moment. But for two, I feel like they trying to throw you under that bus, Javon. You don't see the way that they just said your name right there, and they didn't say nobody else's name inside of who else left their phone on the boat, and I'm pretty sure they know everybody else that left their phone on the boat, but the only person name that they just threw under the bus right there was Javon's name. But here's the thing. I know that them name dropping Javon right there, and this is just my opinion, probably makes them feel like they just did something right there. But the only thing that they just did in my mind is make everybody even more suspicious, and I'll tell everybody why. In order for everybody to follow, I have to go back to the beginning, everybody. We have to go back to the original story that was allegedly told by Javon Williams after the 4th of July when they did the article originally on Javon Williams. Now, the original story from Javon Williams allegedly to that article when he first did that article when they first found 18-year-old Nolan Wells on Monday, July 6th, Javon Williams had allegedly stated to them that him and 18-year-old Nolan Wells had put their phones together on the boat that 18-year-old Nolan Wells rode out there on because they saw each other almost immediately once they arrived to the island due to the fact that Javon Williams said that he was scheduled to be able to ride with Nolan Wells out there to the island, but their boat ended up being too full that Javon Williams ended up needing to ride a different boat out there to the island.
Let's actually play detective with this one, because this isn't built around a theory. It's about comparing what Javon has said at different points with what the friend group has reported. Start with Javon's original account given shortly after Nolan was found. He said he and Nolan had planned to ride out on the same boat, but both boats ended up being too crowded, so he took a different one. He said he left Horn Island around 4 that afternoon, and when he left, he saw Nolan talking with a girl and a group of friends. And importantly, in that original account, he said he and Nolan had placed their phones together on the boat Nolan actually took. Now compare that with what he's reportedly said later across different platforms and at different times. There are multiple accounts, including one attributed to his own mother clarifying a comment. The details about exactly where his phone was and how he got it back have changed. Different locations, different descriptions, and different versions of how the sequence unfolded. We want to be careful here because we can't independently confirm every social media comment attributed to him or his family. And we're not going to treat unverified screenshots as established facts. But if his own explanation of one basic detail, where his phone was and how he got it back, has actually changed more than once, that's something worth pointing out, just as we would with anyone else involved in this case. It's important to be clear about why a changing detail like this deserves attention without automatically suggesting anything sinister. Where you physically left a phone and how you later got it back isn't normally the kind of detail memory distorts under pressure in the same way a fast-moving, emotional sequence might. Timing, who said what, and the order of events during a chaotic evening can absolutely become blurry under stress. And we've made that point consistently throughout this case. A phone's physical location is different. It's a much more concrete fact. It's the kind of detail that can usually remain stable even when everything else surrounding the event becomes unclear, precisely because it doesn't require reconstructing an entire sequence. It's simply, where was the object? If that particular detail has changed multiple times, it's reasonable to examine it under a slightly different standard than a timestamp or a complicated series of events. One version attributed to Javon's own mother, reportedly clarifying a comment, is worth examining carefully because the wording matters. She reportedly corrected someone directly, saying that what actually happened was that Javon made it back to the dock first, and then the boat arrived, which is when he got his phone back. Read that sequence closely. Javin was already at the dock waiting, and the boat carrying his phone arrived afterward. That's a specific order of events, not some vague summary. And interestingly, it lines up, at least generally, with what the friend group's own recent account describes. People reaching the boat launch and then waiting there for others to come back and collect their phones. Here's where the detective work really becomes important, independent of those changing details. The friend group's own recent account says 5 people left their phones on the boat, and they had to wait at the boat launch for those people to come retrieve them, specifically naming Javin as one of those 5. If Javin's original account is accurate and his phone really was on the same boat as Nolan's, then the moment Javin arrived at that dock to retrieve his own phone would also be the moment the group was there with Nolan's phone still in their possession, waiting for a boat that Nolan himself wasn't on. That's the actual question worth asking. And asking it doesn't require assuming anyone was dishonest. If several people were arriving at that same dock one after another to collect their own phones, and everyone eventually got theirs except Nolan, why didn't that particular moment become the first serious red flag? Why not right there at the dock, when the group would have been holding a phone belonging to someone who still hadn't shown up to claim it, just like everyone else had? There's another layer here that connects directly to something we raised earlier tonight. If Javin really was standing at that same dock, getting his own phone back around the same time the group still had Nolan's phone and no sign of Nolan himself, that would seem like the natural moment for someone to take action. Not hours later, after panic had already started, but right then, while everyone was still together and all those pieces were sitting in front of them at once. Instead, based on everything we've gone through in this case, the actual outreach to Christine happened later that night through an indirect route. Warren called Javin specifically to get her number, rather than someone immediately calling her when the group realized Nolan was the one person who hadn't come forward to collect his phone. Now, to be fair, there's an ordinary explanation that deserves to be considered because it's completely possible. Imagine a busy, chaotic dock at the end of a long holiday on the water. People arriving at different times. Everyone tired. Everyone assuming the next person would eventually show up. That's exactly the kind of situation where a warning sign can be missed in real time. Not necessarily because anyone is hiding something, but because human attention doesn't work like a checklist. People don't always stop and connect the fact that everyone else is present while one specific person isn't, especially when there's already an assumption in place. In this case, the assumption may have been that Nolan planned to make his own way back separately with Katie or with another group entirely. But that explanation becomes harder to rely on the more people who were actually present during that exact moment. If 1 or 2 people were quietly exchanging phones in an empty parking lot, a missed connection would be easy to understand. Nobody is necessarily watching for a larger pattern. But if an entire group was standing around a dock, watching person after person come collect their phones while one particular phone remained unclaimed, that's a different kind of nobody noticed. Group situations are often where gaps like this get spotted sooner, not later. More eyes are present, and more people can cross-check who is actually. So it's fair to ask why concern didn't build at that point the same way it eventually did only a few hours later, after the group had already separated and then reconnected on their own. There's also another practical possibility worth mentioning honestly. It's entirely plausible that the group's understanding at that exact moment was still that Nolan was with Katie's group and would simply get another ride back. In that scenario, the fact that his phone was still sitting at the dock wouldn't necessarily have seemed urgent because nobody there believed Nolan specifically needed to retrieve it from them right away. If that assumption was firmly in everyone's mind, having an unclaimed phone at the dock might not have felt alarming at all. It could have seemed like just another loose end to deal with later, similar to any forgotten item after a long day. That's a genuinely reasonable interpretation, and it deserves to be considered alongside the harder question. It's worth stepping back and identifying what makes this particular gap different from many of the other contradictions we've discussed in this case. Most of the issues we've examined involve competing versions of what people said, the wording, the phrasing, who told someone what, and when. This is different. This is a gap in action, not words. It's a moment where, according to the group's own description of events, several specific facts were physically present in the same place at the same time: Nolan's phone, Javin's phone, a boat that had returned without Nolan, and a group of people standing there waiting. Whatever anyone actually said to one another during that moment may be less important than what apparently didn't happen afterward. Nobody seems to have connected those pieces out loud in real time in any way that has been publicly described. And that's the real detective-level question sitting underneath every version of this story, regardless of which account of Javin's phone ultimately turns out to be accurate. The bottom line is this: Javin's own account of his phone has reportedly changed across different tellings. That's worth noting, just as we would with anyone else, while still being careful not to treat unverified social media comments as proof. A physical detail like the location of a phone is generally one of the more stable facts in someone's memory of a chaotic day. But the stronger detective-level question is the doc moment itself. If the group's own account of everyone coming back to collect their phones is accurate, then that moment deserves a direct explanation for why Nolan's absence didn't become urgent right then, instead of becoming urgent only later that night. At the same time, a genuinely reasonable explanation still exists. The group may have believed Nolan was already safe with someone else. So here's the question for you. If you had been standing at that dock, watching everyone else's phone get claimed one after another, at what point would Nolan's unclaimed phone have started?
Journalist, author of Down the Hill, My Descent into the Double Murder in Delphi. What witnesses? I understand that there's video and witnesses. One places him there at 5, one places him there at 6. Significance: the Triton, and we can show this by GPS, they are right about this, left Horn Island around 4:30. So if he is spotted, and you can confirm to me that he is spotted there at 5 or 6, if that video has a timestamp on it, and I can corroborate that, or I can corroborate the witnesses weren't drunk. Hey, let's see that video control room again of Nolan bent over, and all you can see is his blue trunk right there. Now, that's not a very good eyewitness right there, okay? Do I think that's him? Yeah, I do. I do think that's Nolan. But I would tear that up in court. Tear it to shreds. There's all sorts of... You know what? Hold on, Susan Hendricks. Greg Morse joining me, veteran trial lawyer, founder of Morse Legal. He's in the Southern District of Florida, former West Palm Beach public defender, and author of The Untested. Greg, in Florida, as in Georgia, as in this jurisdiction of Mississippi, the code, the official code of Mississippi, annotated, lays out how you establish or cross-examine, same thing, same criteria, an eyewitness, such as, I memorized them. How far were you away from the witness? From the target. What was the lighting? Do you wear glasses? Were you wearing them that night? Were you inebriated? Had you smoked pot? How can you prove that to me? Did anything obstruct your view? Was it daytime or nighttime? What time of the day was it? What were the conditions? You go on and on and on. You can rattle them off, right? I know you can. So
absolutely.
How do I know the eyewitness can't identify anything except the back of his legs, like in that video?
Well, that's the thing. There's no details about any identification. It's just a broad statement that other people saw Nolan after the boat left.
There are two threads we need to look at tonight, and both of them become much clearer when you examine the details more closely than they have been anywhere else in this case. Because once you really dig into them, both actually have concrete answers, the kind of answers an investigator would want before accepting either version at face value. Let's start with the 6 o'clock witness claim, because this week it finally received the kind of examination it should have gotten from the start. An actual trial attorney applied the real legal standard for eyewitness identification instead of simply repeating whichever side sounded the most confident. Attorney Tyler Cox's position has been very firm. 2 reliable, credible witnesses who have known Nolan for years positively identified him, with supposedly no realistic possibility of a mistake. But a detective doesn't treat no chance of a mistake as a finding. That's a conclusion. The job is to go backward and examine the process that produced that conclusion. And that's exactly what happened next. It's worth breaking this down like genuine casework because that's essentially what it was. Florida trial attorney Greg Morris explained the actual legal factors used across Mississippi, Florida, and Georgia when evaluating or challenging an eyewitness identification. He went through them from memory, the way an experienced trial lawyer would in court, rather than repeating a prepared talking point. How far was the witness from the person they were identifying? What were the lighting conditions? Were they wearing glasses, and were those glasses actually being worn at the time? Had they been drinking or smoking anything? Was something blocking their view? Was it daytime or nighttime? What were the actual physical conditions at the location? That's not just a rhetorical checklist. Every one of those questions is something a detective building a real case file would need answered before treating an identification as reliable enough to build a case around. And publicly, those questions still haven't been answered for either of these two witnesses. Not one. Then those same questions were applied to the one piece of footage that is actually available, and suddenly the evidence looked much less convincing under closer examination. The clip being discussed shows someone bent over, viewed only from behind, with the visible detail being the back of a pair of blue trunks. Susan Rise put it plainly, that's not a particularly strong position for an eyewitness identification. Greg Morris went even further, breaking down what the footage doesn't establish, almost like going through a case file and marking every missing piece. There are no details about sunglasses. There's no confirmation that the person was truly familiar enough with the individual being identified. There's also no information about how much anyone had actually been drinking that day, in what he accurately described as a party environment. He compared it with a similar boat location he had personally seen near his home in Florida. And his conclusion was delivered as directly as you'd expect from a trial lawyer evaluating evidence from that position. That's not a strong identification. In an actual courtroom, it's exactly the kind of testimony he would challenge aggressively during cross-examination. Here's the bigger case file issue behind why this matters beyond one short video clip. No chance they made a mistake is a final conclusion. A detective can't properly close an investigative question based on a conclusion that hasn't survived the questions supporting it. Once the standard identification factors are applied to this particular evidence, that absolute and confident presentation doesn't hold up quite the way it was originally described. That doesn't prove the sighting never happened. It simply means the level of certainty attached to that sighting appears stronger than what the available case file currently supports. And an investigator would normally leave that question open rather than close it until those specific gaps are answered. Now let's move to the phone because this is where we have actual dates, and that changes the nature of the discussion. This isn't simply about impressions anymore. It's a timeline that can be built directly from the reported record. On July 15th, Nolan's family met directly with the Jackson County DA's office. According to the family's own team, specific terms were discussed and agreed upon during that meeting: a joint, one-time examination of Nolan's phone involving the DA's office, the family's independent forensic team, and potentially the FBI, with everyone present together and working from the same extracted information. The family's concerns were also clearly laid out during that meeting: chain of custody, who would have access to the extracted data, preservation of the evidence itself, and when the phone would eventually be returned, since they describe it as the last physical item they have belonging to their son. Here's the gap a detective would immediately notice after that July 15th meeting. There was no follow-up from the DA's office for almost a month. Then, on August 12th, the DA's office sent the family a demand letter giving them 48 hours to turn over the phone. The family was separately out of town at the time. And according to the family, this appears to be an earlier example of the same basic pattern. They have also described receiving a previous demand that gave them only 24 hours, while they were specifically attending the National Association of Black Journalists conference in Georgia. That's a professional commitment, not automatically evidence of evasion. Their response on both occasions followed essentially the same position. The parties had agreed to a joint process on July 15th, they were not hiding the phone, and they could make themselves available with reasonable notice, provided they received roughly 24 hours to arrange everything. Now do the actual math on that timeline, because the pattern may matter more than any single date. Nearly a month of silence was followed not by a scheduling discussion, but by a strict deadline, and on both occasions the short deadline arrived while the family happened to be away. That's not just one missed communication. It's a repeated pattern. And an investigator wouldn't necessarily treat a repeated pattern the same way as one isolated misunderstanding. A demand letter allowing only 24 or 48 hours, sent while the recipient is already known to be traveling, doesn't create much of a realistic opportunity to comply. By the time the letter is received, opened, and understood, a substantial part of that limited window may already have passed. We want to state this as clearly as the source material presents it, because the point matters. The family's stated requirements, chain of custody, limits on data access, evidence preservation, and a clear return timeline, are not, by themselves, obstruction. They're standard safeguards that can be part of a properly documented forensic examination. These are the same kinds of protections we discussed in detail earlier in this video. Wanting those points confirmed before handing over the last physical item connected to your son isn't automatically resistance. In this context, a family asking for those protections can reasonably be viewed as trying to make sure the process is documented, rather than simply refusing to cooperate. There's also a documented reason why this particular caution could make sense, independent of anything specific to Nolan's case. The Ellen Greenberg case was raised as a comparison. In that case, a crime scene was professionally cleaned before it was properly processed. Video evidence that was supposed to establish what happened was later lost after being handed over to police, and a computer removed from the scene was reportedly never examined. Nobody is saying the same thing is happening here. What the comparison actually shows, case file to case file, is that evidence handling problems are a real documented risk. They have happened in other cases, including cases that were not necessarily as publicly contested as this one. That's why a family in Nolan's position asking for documented safeguards instead of simply relying on blind trust isn't automatically paranoia. It's a reasonable response to a type of risk that has affected other families before them. So here's where these two threads stand when we look at them like an actual case file. The 6 o'clock witness claim does not fully survive the real legal standard for eyewitness reliability once those criteria are properly applied. That doesn't disprove the sighting, but it does make the claim considerably weaker than the absolute, no chance of a mistake framing suggests. And the weaknesses are specific. They're identifiable, and several remain unanswered. The phone cooperation question has a dated, documented timeline. There was an agreement reached on July 15th. Then nearly a month passed with no follow-up, followed by 2 separate short-notice demand letters, both arriving while the family was traveling. That's not necessarily a case file proving the family simply won't cooperate. Instead, based on the timeline described here, it shows that a process was reportedly agreed to once, but the follow-up did not happen in the way that agreement appears to have anticipated. So between the eyewitness claim and the phone timeline, which one changes the way you look at this case more?
The video you just showed shows from a view from behind of someone bending over. Did the person have sunglasses on? Were they familiar with who they were actually looking at and identifying? You know, how much had they drank during the day? It was a party scene. That's what usually these boat spots are. There's one by me in West Palm Beach, very similar setup called Peanut Island. So most people also, right, they don't think something's important until after the fact. They're just going about their day, notice people walking by. So from what you showed, that's not a very strong identification from that position, but there's no details.
You know, while I've got you, Greg Morris, let me throw another question at you. And look, I'm not wearing a prosecution or a defense hat. As you know, I'm a crime victim. I would say I'm coming at it from that angle. But I was very disturbed, Greg, when I got wind that there is no criminal investigation. It's been said over and over and over. Why not? We don't know how he died. For instance, if he did have water in his lungs, okay, maybe he did drown. But how did he get in the water? Did he fall in the water? Was somebody, wrestling with him in the water and they held him down? They went, oh, my stars, I killed him and left. Did he hit his head?
Well,
I mean, there's a lot more to it than saying, oh, yeah, he drowned. How can someone state there is no criminal investigation? I understand a grand jury is about to be convened. That doesn't mean there's a crime, but doesn't that suggest to you a grand jury inside the Superior Courthouse, inside the district attorney's office, would suggest there is a criminal investigation?
Well, it would potentially lead someone to believe that, yeah, a criminal investigation was undergoing. However, when we look at how this has played out over the last 6 weeks, how law enforcement has acted, they haven't seized Nolan Wells' phone at this point. In a criminal investigation,
Put him
law
up.
enforcement's going to use those tools
Put
to
him
get
up.
this information.
Are
So
you
this could
sitting
just be
down,
a
Morris?
drowning. I'm sitting down, and this could just be a drowning. And that's why they're looking at
Yes,
it
it
that way,
could.
because
Nobody's
nothing's told
fighting
them
with you yet.
but everything's not a
Oh
crime. It
my
doesn't have to be
stars.
investigated as a
You're
crime.
still talking. We've already established that. Here's the other, you know what? I'm going to let you think about what you just said. I'm going to go to Jeff Shetler joining us. Guys, this is a special guest joining us out of Edisto Island, South Carolina. Former police K-9 handler, author of 5 books. Last one, 2 weeks to operational tracking. I like this one. Red Dog Rising. K9 trailing. The straightest path. Tactical tracker teams. The Tao of trailing. He is at gak9.com. Question. I get this a lot from the viewers, so you can put it to rest. How long does a person have to be dead before a cadaver dog will pick up on that scent?
Well, honestly, a dog's going to pick up on the live or dead scent as soon as they're out there. So the time frame, from hours to a day or so is really not a big deal. It doesn't matter what type of dog you have that's looking for humans. Within that first 24 hours, either type of dog, a live find or a deceased person dog, is going to be viable. They're going to pick up on anything that's there. The big issue that we have here is primarily the contamination. After the fact, if the dog was placed at the scene initially to search for our victim, then the chances are the success rate would actually be pretty good. The island is very, very small. There's not a lot of hiding places. There's not a lot of places he could go. On the other hand, inside the water might be a different story. We have tide issues and everything else that are occurring there.
So you bring in a scent dog. I would assume you bring in a scent dog first. But the issue with that, in my mind, probatively, like what can I use? How can I use that trial? What's it going to prove for me? I already know Nolan was on the boat to start with. So, of course, the dog is going to pick up Nolan's scent on the boat. That's not hard to figure out. So I know a scent dog is going to pick up on that. But a cadaver dog. What should have been done immediately with a cadaver dog. And I'm putting this out there not to say woulda, coulda, shoulda. Maybe it happened and we...
This part focuses on one specific credentialed voice saying something that deserves to be heard in full before we break it down. A former county prosecutor with 30 years of criminal trial experience is speaking directly, by name, to District Attorney Angel Mears Mrath. Let's begin with the actual legal reasoning behind his message, because it's more important than it may sound at first. His main argument isn't about deciding who is right in the underlying dispute. It's about a basic principle of public communication that, based on his professional experience, a prosecutor can't simply ignore indefinitely. If the family's legal team sends a formal letter saying an agreement was reached in July, and that letter goes unanswered, uncorrected, or unaddressed, the public isn't unreasonable for assuming the account in that letter is accurate. In that particular situation, silence isn't completely neutral. It can function like agreement by default, whether or not that was ever the DA's intention. Now let's examine that logic ourselves, because it does hold up in an important way. A formal legal letter isn't the same thing as a casual social media post. It's a document sent through actual legal channels that makes a specific factual claim, that an agreement existed, that certain dates were discussed, and that the family's side was ready and willing to move forward. If any of those statements were incorrect, the obvious response would be a formal correction explaining exactly what the agreement was or what it wasn't. According to this same commentator, as of this broadcast, that correction never came. That doesn't prove the letter is accurate, but it is exactly the kind of gap a real investigator would immediately flag. A specific and checkable claim was made formally, yet the response was silence rather than confirmation or denial. Here's the distinction he makes that may be the most important point in this entire segment, and it's worth putting into our own words because it cuts straight through a talking point that has been repeated throughout this case. There is a genuine difference between interfering with an active investigation and simply correcting a factual statement about a scheduling agreement. Refusing to discuss evidence, theories, or investigative findings can be a legitimate and defensible legal position, and we've acknowledged that throughout this case. But confirming or denying whether a particular meeting happened on a particular date with particular terms doesn't reveal evidence. It's simply answering whether an administrative fact is accurate. Treating both things as equally off-limits under the broad idea that any response could compromise an investigation is where his criticism becomes much stronger, and honestly, it's a fair point. He also raises something else that deserves serious consideration. Distrust in an investigation doesn't necessarily require proof of wrongdoing before it becomes a genuine problem on its own. If a community loses confidence in the process, even if the investigation itself is being handled correctly, that loss of trust becomes a separate obstacle to people accepting the eventual outcome as legitimate. Whatever the final result turns out to be, a prosecutor with 3 decades of experience is telling you directly that silence in response to a specific unanswered claim is exactly the kind of thing that creates that distrust, regardless of whether anything improper actually occurred. Now let's explain what he's talking about when he mentions the phone being downloaded into a computer program, because most of the public discussion around this has stayed fairly vague about the actual technical process. And understanding that process matters. The tool he's referring to, Cellebrite, is one of the most widely used digital forensics platforms in law enforcement around the world. It doesn't work by someone simply scrolling through the phone, opening photos, and checking messages one by one. Instead, it can perform what's known as a logical or physical extraction, creating a detailed copy of the device's data and transferring that information to a separate secured system. Here's why that difference matters in a case like this. A full extraction can capture much more than what is simply visible on the phone's screen. It may recover deleted material that remains in unallocated storage. It can also provide metadata showing when a file was created, modified, or removed, along with a detailed time-stamped record that doesn't depend on someone's memory or personal version of events. Once that extraction is completed, both sides, the DA's office and the family's independent forensic team, can separately examine the same complete data set, with each side performing its own analysis from the identical underlying copy. Neither side has to rely solely on the other's description of what the phone contains because both sides would have access to the actual extracted data. That's precisely why the joint inspection process reportedly agreed upon in July makes procedural sense. And it's also why changing that agreed process, if that's in fact what happened, would be a legitimate and specific concern separate from the other issues in this case. A single joint extraction performed with both sides present, followed by both sides leaving with the same complete mirror data, is a defensible forensic approach. A demand for the phone to simply be handed over without that same joint process isn't automatically improper by itself. Law enforcement can have independent authority to obtain evidence through proper legal channels. But if a real agreement already existed that called for a different joint process, then abandoning that arrangement without explaining why is exactly the kind of unnecessary problem the former prosecutor is talking about. There's another layer of this process worth understanding because it directly addresses one concern that has come up repeatedly in this case: the possibility of evidence being mishandled or changed afterward. A proper Cellebrite extraction can generate what's called a hash value, essentially a unique digital fingerprint for the extracted data set at the moment it is created. If that data is later copied, transferred, or examined, the hash can be calculated again and compared with the original. If even one bit of information has changed, the values won't match, and that difference can be detected mathematically. Built-in safeguard that can make a properly documented joint extraction reassuring to both sides. Not only does it protect the family's desire for independent access, it also protects the DA's office by preserving the integrity of whatever information the phone actually contains, regardless of where that evidence eventually points. Here's the detective-level significance underneath all of this, and it needs to be stated clearly. Nolan's phone could contain the most complete, objective, time-stamped record of his final hours available anywhere. It can be more precise than one person's memory and more reliable than a second-hand account of what happened. There are also public allegations that information on the device may have been altered or deleted. A complete forensic extraction is specifically designed to examine claims like that. Deleted material can sometimes remain recoverable in unallocated storage for a meaningful period of time. That's the same technical issue we've discussed elsewhere in this case. At this point, getting that extraction completed through whatever legitimate process ultimately resolves the disagreement is extremely important. It may be the single piece of evidence most capable of either confirming or resolving a significant number of the unanswered questions surrounding this entire case. There's one final piece of context worth adding because it explains why this delay matters so much. Every other contradiction we've discussed throughout this video, the missing return footage, the changing accounts about the phone, and the doc moment nobody has fully explained, continues to exist in a state of uncertainty partly because the one piece of evidence capable of answering several of those questions at once has, according to the former prosecutor's account, remained unresolved since July. One properly documented extraction wouldn't only answer the narrow question of whether anything was deleted from Nolan's phone. Depending on what the device contains, it could independently support or challenge parts of nearly every timeline disagreement this case has produced. So here's the bottom line. The former prosecutor's central argument holds up under closer examination. A formal letter making a specific factual claim that receives no response isn't completely neutral. And there is a legitimate distinction between protecting an active investigation and simply correcting the public record about a scheduling disagreement. The forensic process he's describing is a standard, defensible approach that can give both sides confidence that they're examining the same complete data set. What's still missing is exactly what his message is asking for: a direct public explanation of whether the July agreement is being honored. And if it isn't, why not? If you were the DA hearing this message directly, what would actually prevent you from simply answering it? Yes, there was an agreement. Or no, here's what actually happened.
Wells, would you just be blindly turning over that cell phone after they promised a joint investigation? I'm going to take a shot in the dark here and say that you probably would not turn over that cell phone, especially when the district attorney for Jackson County, Mississippi, specifically said, "We will offer a joint investigation with our investigators and you as the family, and we will dissect and extract any information on that phone to confirm if any at all information has in fact been destroyed." But you guys saw that in a legal document sent on August 11th, that joint investigation logistics have not occurred yet. They have not reached out to the family yet to say, hey, these are the days that work. Now, I know social media and I know the public are running around with this saying they are not cooperating. No, they're cooperating, but they're doing something intelligent, saying, we're not just going to hand over the phone. You promised us a joint investigation. Well, we want you to make good on your word. When will that joint investigation and cell phone extraction actually occur? When we know, we'll be there and we will physically hand over the phone, but not until then. That's not cooperating. That's not obstruction of justice. That is the family waiting for the district attorney to make good on her word.
The phone in the Nolan Wells case. I have a message directly to DA Angel Myers McGrath from a former prosecutor who did the same job you did, 30 years criminal trial experience, certified criminal trial lawyer, former head county prosecutor. Please listen carefully. This phone issue is getting out of hand. Nobody knows what to believe because you keep refusing, as I've said previously, to do proper public relations. Now, supposedly, there's a letter out there that says you agreed in July to have the phone examined with the experts from the family at a specific location and in a specific way, and that they are ready, willing, and able, and gave 4 dates this week where they would be willing to surrender that phone for examination. Now, I've been involved in things like this, so I don't know what's been said or hasn't been said, but I'll say this. The only story that we're listening to is that from Nolan Wells' family. And when they send you a letter and you don't respond and correct that letter, then we can only presume rightly that what's in that letter is correct. So the question becomes, if you had an agreement in July, why is it not being honored? There are accounts that you have demanded that the phone just be turned over in violation of that agreement. And that is not a good thing, not a good look. I can tell you from the commentary on the posts that I've had that your constituency out there in Mississippi does not trust law enforcement and does not trust this investigation. Your continued failure to update the community on any misinformation, if there is misinformation, or say, for example, if this agreement is not what the agreement was, then you need to get out there and you need to let the public know. Now, Stop with this thing that you don't compromise investigations about speaking about them. I've addressed this before. You are not compromising an investigation by correcting the record. You are making sure the public has an understanding, so we can only presume what's been written by Mr. Crump and his team is accurate. That phone is vital to any grand jury presentation. If you don't get that phone and you don't download it, then you are going to look like a bum no matter what it is that you do, and nobody will ever trust the investigation. To be honest with you, I wouldn't trust it either. That phone is vital. There is allegations that there's destruction of evidence that's on that phone, and we need to see what's on it and what's not on it. And for the rest of the folks that are out there, understand, they're not going to be going through the phone picture by picture, page by page. This is downloaded into a computer program called Celebrate, and from there, there's extractions that are done, mirroring of the phone, and then both sides can be confident they have all of the information. There's nothing wrong with that. Now, DA, I can hear you say, well, we're going to be setting a precedent that everybody thinks that they have a right to have their people there when they examine the phone. Well, you know what? I don't know, and I don't care. If you agree to that in this particular situation, we'll look at it like a one-off, but the community, me, everyone out there, and certainly the victim's family need to know it's been done in the right way. So